It's a great honour to be invited to speak to this prestigious conference on the very important topic of the role of the athletes in delivering the good governance of sport. Uni World Athletes is the global voice of the athletes, representing over 85,000 professional athletes, including 65,000 FIFPro footballers, bringing together over 100 player associations in more than 60 countries in sports such as football, cricket, rugby, basketball, ice hockey and baseball. Our vision is clear: to champion the dignity of the athlete and the essence of sport. And as a number of speakers have said, it's a particular honour to be speaking on the 15th of December. 1965 was the establishment of FIFPro, and we need to acknowledge George's involvement in that. And of course, it's 20 years since John Mark's case. But let's not just celebrate the courage and the intelligence of our legal legends. Let's also celebrate the overwhelmingly positive impact that their stances had on their industries, both as sports and as businesses. And we can quote David Fear's partner, as I did to the FIFPro Congress on the weekend, Jeffrey Kessler. What history has taught us? What history has taught us is that there's no inconsistency between having a fair system for players and having a healthy sport. Quite the contrary. What we've seen is that when sports have given players more freedom and have compensated them better, the entire sport has grown on the revenue side. The players and the clubs can work together to build the sport much more easily in a fair system than in an unfair system. And we should not be surprised by this impact. Labour law exists to provide dignity for workers, to provide for better work, to provide for more productive employees, to provide a career path. And competition law exists to foster innovation, creativity and growth. And collective bargaining to succeed requires, in addition to leverage, three fundamental things: trust, mutual understanding, where the workers understand what's required to make the business succeed, and business understands what it means to provide meaningful work, and a shared vision of where that business or that industry should be going. So where is the governance of sport today? We need to define the very best model in the world before we can determine the athlete's role and position in delivering good governance. And we can quote Dr. Francois Carrard in his report of the 2nd of December. FIFA is facing the worst crisis in its history, and significant modifications are needed to prevent corruption, fraud, and self-dealing. Now, I want everyone in this assembly to know one thing. There are no more replaceable people in football than the football administrators. Out of everyone involved, they are the easiest ones to replace. If we look at WADA, Dick Pound, the president of the recent WADA Independent Commission, found systematic cheating in Russian athletics, which involved the governing body and the anti-doping agency. It involved the exploitation of the athletes, who were told cheat or be excluded. And it involved bribery and corruption at the highest levels of the International Athletics Federation. But it also made critical comments regarding the governance of WADA itself. And I quote from the report: "Actual and potential conflicts of interest in the WADA Executive Committee and the Foundation Board make decisions regarding WADA code compliance unnecessarily difficult to achieve." And of course, if those actual and potential conflicts exist at the highest levels of WADA, then they will affect every decision that WADA makes. I approach this discussion with two perspectives going back 20 years. The first is as an Australian, and the second is as a player association leader. In Australia, our sporting industry sees good governance as essential to growth and prosperity. We do not see the governance discussion as being about defending a sport from corruption. It's about excellence and it's about growth. And also I approach it from the perspective of being a player union leader in Australia that had to organise the players around three principal reforms: closing down an inept governing body and setting up a new one, closing down a league that was not viable and setting up a new one, and of course our move into Asia. And in that process, the players adopted the philosophy that the well-being of the game is a precondition to the well-being of the players. Therefore, the players must shape the future of the game for the better. And perhaps that philosophy is now called for at the global level. The athletes have a deep interest in good governance. They are in many ways sport's most objective stakeholder. They have a professional and emotional engagement. They're involved in all aspects of the professional game: big clubs, small clubs, every club in between, national teams. They started at the grassroots and have been part of the elite development systems. They understand the community, and well-organised athletes, as David Fears said yesterday, care for the next generation. So they'll take a long-term perspective, and they feel deeply the impact of poor governance, abuse, corruption, non-payment of salaries. And as FIFA's Don't Fix It campaign shows, players have their own sense of integrity, the number one defence to the prevention of match fixing and other threats to the well-being of sport. And of course, as we know, athletes are simply essential, unlike the administrators, to the generation of sports wealth. In 2014 FIFA World Cup in Brazil, 64 games were played. 736 players were involved. And that generated $4.83 billion of FIFA's revenue of $5.72 billion for that cycle. Payments to the participating countries were $354 million. That means if we assume the players receive 30% of that, which is probably on the high side, the total payments to the players were between 1.8 and 2.2%. The total prize pool for the Women's World Cup was $15 million. That's payments to the countries, not the players. 0.3% of FIFA's revenues. So, as the drivers of the game's wealth, the players have a key claim to a major say in the governance of sport, which is certainly the equivalent of any other stakeholder. So where do we begin? The starting point for reform is, as we learned today, of course, the autonomy of sports. And I quote Dr. Arnett Gerard from the Sports Governance Observer of 2015, released on the eve of the prestigious Play the Game conference held a couple of months ago in Denmark. Even though they have allowed politics to influence their policies and decisions, autonomy from formal regulatory public interference is an obsession for international sporting federations. It's an essential part of their belief system, a doctrine that they aim to spread among political institutions and stakeholders in order to keep the governance of international sport strictly private. The autonomy of sports seeks to have one of two impacts on athletes. One, it excludes them, and if it can't exclude them, it controls them. This gives rise to what we call the athlete's choice, which is no choice at all. As the President of the Court of Arbitration for Sport, John Coates, said recently, who also happens to be the Vice President of the International Olympic Committee and the President of the Australian Olympic Committee, intrusions into the liberties of athletes such as from WADA are, quote, part of the privilege of being an Olympian, part of the privilege of participating in the sport. So what does that mean on discipline? The athlete's choice. Agree to WADA or forfeit the right to work. On dispute resolution, agree to have your disputes resolved by the Court of Arbitration for Sport or forfeit your right to a career. And on labour market regulation, as George said yesterday, agree to be the property of your club or stand down from football. And as we talk about Bosman's decision today, let's reflect on Advocate General Lenz. That attitude presupposes precisely that a player can be regarded as a sort of merchandise for which a price is to be paid. Such an attitude may correspond to today's reality as characterised by the transfer rules, in which the buying and selling of players is indeed spoken of. That reality must not blind us to the fact that this is an attitude which has no legal basis and which is not compatible with the right to freedom of movement. I also have considerable doubt as to whether a system which ultimately amounts to treating players as merchandise is liable to promote the sporting ethos. But of course, in recent years, we had the Methuselah decision, and the Court of Arbitration for Sport relied on the specificity of sport to develop and re-engineer the transfer market and talk about a player's market value. So there's only one way to replace the athlete's choice with an athlete's agreement, and that's to establish the right to organise and collectively bargain, as FIFA is now doing in the women's game. Pay, discipline, health and safety, labour market regulation, dispute resolution. These are all common, even mandatory subjects of labour law and collective bargaining. But sport avoids this fundamental right of athletes at the global level. The response by WADA to the initial moves to establish Uni-World Athletes is a case in point. Then WADA Chairman John Fays minuted remarks to the WADA Foundation Board on 20 November 2011 read as follows. He thought that it was incumbent on all who believed that sport was a very different and separate operation to other workplaces to make that clear. In his opinion, the least amount of credibility given to these people, the better. They must be seen for what they were, a union. And if individual sportsmen and women wanted that, that was their choice. But WADA should make this clear at every opportunity that under no circumstances would it recognise them as being representatives of the sportsmen and women of the world. And back to Mr. Coates. These are the unions who are not elected representatives of the athletes. I know who they are. When asked whether he thought that players or athletes should not have union bodies representing them, he said, I think our position is that all bodies should have athlete representatives on their board who are elected by the athletes themselves. That is the case with the athletes' commissions in the national federations and the Australian Olympic Committee. It is not some other self-appointed body that goes out and negotiates wages and other matters for them. Those words are from the President of the Court of Arbitration for Sport. Of course, athletes' commissions do not introduce the necessary levels of accountability for good governance. The Charter of the Athletes' Commission of the Australian Olympic Committee, for example, provides that the Commission's role is to advise the Australian Olympic Committee and obliges each member of the Athletes' Commission not to act in the best interests of the athletes, not even to act in the best interests of sport, but to act solely in the best interests of the Australian Olympic Committee. The right to organise and collectively bargain is enshrined in Article 20 of the Universal Declaration of Human Rights and Conventions 87 and 98 of the International Labour Organisation is, of course, a fundamental element of any civilised labour law. Recognition and respect for the right to organise and collectively bargain involves an obligation on the part of all employers and their representatives not to interfere with the independent pursuit and exercise of that right. And so firstly, good governance in sport demands the recognition of the right of athletes to organise and collectively bargain. So what's the best governance model in the world? We can go back to Dr. Girard. He said there's 4 issues: transparency, democratic processes. And as far as the athlete's concerned, that box was based on athletes' commissions, made no mention of player associations or innovative devices such as the Dutch Players' Council in football. It says we need checks and balances and we need solidarity. He then assessed the 35 international Olympic federations by reference to that 4 criteria, and FIFA came in second, number 2, behind equestrian, I think. So we can put that model to one side and let's really look at what the best model is. And if we cite genuine experts, such as David Crawford and Colin Carter from 2011, or the Council of Europe, we talk about 3 things: independence in the governing board, skill and judgment, a diverse board of a workable size, and accountability. which includes the right of the owners or the shareholders or the members, howsoever they're described, to appoint and remove the governing board and agree to the major game-changing decisions. So let's talk about the central case of FIFA. It's notable that when Mr. Blatter announced his resignation, he said that even though he had the support of the members of FIFA, he did not have the support of the stakeholders who love the game, including the players and the clubs. But in July, he appointed representatives of the 6 confederations, as Sylvia has mentioned, to devise the reform process, even though those 6 confederations and their member associations were principal architects of the corruption scandals we're now dealing with. What are the weaknesses of Dr. Carrad's report? Well, it's the flawed design of the proposed FIFA Council, which is the renamed Executive Committee. It says it's to provide a strategic function, but it's largely representative, and it is an ineffective decision-making model. It's 36 people, and there's no reference to skills. The emphasis is on participation, not accountability, and the fundamental question of who owns FIFA is not addressed. The power is kept exclusively with the member associations and the confederations. And indeed, the existing stakeholders are rewarded in a document which is meant to be a governance review. It says, we will give you more spots in the World Cup. We'll increase the spots on the Executive Committee for you, and it even advises FIFA to reduce investment in competitions and administration so that increased football development funds can be paid to the member associations. And as far as the players are concerned, we're to be anchored into a yet-to-be-defined Football Stakeholders Committee to be supervised by the FIFA Council. So, good governance in the athletes. 2 principles I commend to you. The first is accountability, which requires ownership or agreement. We should be able to agree to the terms upon which we are required to participate. And partnership, which requires trust, mutual understanding and vision. I want everyone who represents athletes to adopt this. Mere participation is not enough. And that is all the proposed FIFA reforms deliver. Absent ownership, therefore, FIFPro and all the athletes' unions of the world have to organise to create leverage, and we have to bargain. We need legal leverage, economic leverage and industrial leverage. And these bargains, as we know from our legal legends, will deliver better outcomes for sport and the athletes, as history has shown. Let's look at the example of baseball and the partnership designed by the president of Uni World Athletes, Don Fehr. The New York Times recently asked the question, just how far has this partnership propelled baseball? It involved revenue sharing amongst the clubs, a luxury tax instead of a salary cap, but very innovative ideas such as a joint venture of the global strategy. This means that the World Baseball Classic, baseball's equivalent of the World Cup, is a joint venture between the Players Association and the owners of the Major League Baseball clubs. And any international match played by Major League Baseball is conducted on the same basis. But let's have a look at, for example, doping. We're told we must accept the WADA code despite its ineffectiveness. If I can quote the words of the late Mike Weiner, the former executive director of the Major League Baseball Players Association, the players are determined to do what they can to continually improve the sports joint drug agreement. Players want a program that's tough, scientifically accurate, backed by the latest proven scientific methods, and fair. I believe these changes firmly support the players' desires whilst protecting their legal rights. We want to prevent doping, not just fight it. So, the opportunity exists for FIFA, the leagues and the clubs to partner with FIFPro to negotiate a regulatory regime that does not get its legitimacy from the vague sanction of the autonomy of sports. Instead, that legitimacy comes from an informed collective bargaining agreement that empowers the game's key stakeholders to drive the growth and development of the game. At a minimum, that agreement should address the essential subject matters of collective bargaining, such as remuneration, discipline, health and safety, dispute resolution, labour market regulations and the protection of players from the abuses we've heard so much about in the last 2 days. In the interest of good governance, it also needs to address revenue sharing, commercialisation, game development, and the terms on which players will agree to play in major tournaments, and the involvement of the players in the governance of those tournaments and the decision-making of the game. But such a partnership can only be developed based on trust, mutual understanding, and a shared vision for the game. It all comes down to respect. And the players must be able to trust the governing body. Therefore, the overhaul of FIFA's governance to adopt the best model of governance in the world is a prerequisite to the development of any partnership with the players. I'd like to thank you for your attention, and there is a paper that I've written which provides more detail to those words. Thank you.